Welcome back to the Deep Dive. This is the place where we take a stack of your sources, roll up our sleeves, and really dig in to pull out the most important nuggets of knowledge and insight.
Yep. Think of it as your shortcut to getting really well informed quickly and thoroughly on the material you bring us.
And we're your guides through that material.
Yeah.
Today, you've brought us a really substantial set of sources focused on family law.
Mm-hmm. And it looks like you're after a full foundational breakdown, something that gives you the solid comprehension you need, maybe for essays, maybe just for building that base understanding of the field.
Absolutely. And family law, it's such a critical area, isn't it? It touches on these core aspects of people's lives.
It really does.
So our mission for this deep dive is simple. We're going to systematically unpack the core concepts, the rules, the procedures outlined right here in this material you've provided.
Make it accessible, make it clear. We'll pull out those key details you need to grasp.
And the sources cover a lot of ground. How marriages are formed, how they end, financial support, alimony, child support.
Right. And the really complex areas like child custody, visitation, what role agreements play.
And how the state fits into all these family matters. It's a huge field.
It is. And it's fascinating because family law, it's not just abstract rules on paper, is it? It's the legal framework governing some of the most significant emotional, personal moments people experience.
Forming partnerships, raising kids, ending relationships.
Exactly. So understanding this legal structure is incredibly important because it's so tied up with real human experience and often, legally quite complex.
And just a reminder, like always, we promise to stick strictly to the information provided right here in your source material. We're here to help you understand what's in your sources.
That's the goal.
Okay, let's dive in. Let's start right at the very beginning, just like the sources do. Marriage itself.
Right, the foundation. According to this material, the law sees marriage, fundamentally, as a civil contract.
A contract. Okay, so like signing a lease or a business deal. Is that the idea?
In a way, yes, but there's a really critical difference the sources flag right away.
Okay.
It involves parties who are legally capable of consenting. You know, they exchange mutual promises. It imposes rights and obligations.
Mm-hmm. Sounds like a contract so far.
But here's the unique part. Unlike most contracts, a marriage contract cannot be modified or terminated without the state stepping in.
Ah, okay. So you can't just shake hands and call it quits.
Nope. The state is involved. From getting the license right through to the final divorce decree, it underscores the state's really significant ongoing role in this specific type of contract.
Got it. So this unique legal structure. The sources then talk about two main types of marriage that are recognized.
That's right. Ceremonial marriage and common law marriage.
Let's tackle ceremonial marriage first. That sounds like the more familiar one.
It generally is. The source outlines two key steps. First, the couple has to get a marriage license.
Right.
And second, they need to participate in a ceremony, which is also called solemnization.
Okay, license and ceremony. So walking through the license requirements, what is the source detail there? What do you need to get the license?
Okay, several requirements are laid out. There are age restrictions. All states have a minimum age, usually 18. But younger folks can often marry, with parental consent or maybe a judge's approval.
Right.
There might be a waiting period, a set amount of time between applying for the license and actually getting it or having the ceremony.
Okay.
And here's an interesting point the source brings up. States can require premarital medical testing.
Oh, like blood tests.
Could be. But, and this is the nuance, they cannot refuse to issue the license based on the results of that testing.
Oh, so they can make you take the test, but the outcome doesn't stop the marriage license itself.
Seems that way based on this material. It sounds like it's more about informing the couple rather than creating a legal block based on health.
Interesting. Anything else for the license?
Yeah, most licenses have an expiration date. You have to actually have the ceremony before the license runs out.
Makes sense. Okay, so those are the hurdles to get issued a license. What about reasons a license might be flat out denied? The source lists specific grounds?
It does. Figure 1A in the source lays these out. A license won't be issued if one person already has an existing prior marriage that hasn't ended legally.
Right, bigamy.
Exactly. Or if the parties are too closely related, the incest issue.
Right.
It could also be denied if it's deemed a sham marriage, meaning the couple doesn't actually intend to be married. Maybe they're doing it for immigration purposes or something.
Lack of real intent.
Right. And finally, denial can happen if someone lacks legal capacity. Maybe they can't understand what marriage means, perhaps due to drugs or alcohol at that moment, or if there's duress or fraud involved in getting their consent.
So basically preventing marriages that are legally flawed from the start. Makes sense. And the sources mention same-sex marriage specifically.
Yes, states clearly it's permitted and recognized in all states.
Good. Okay, so you get the license, then comes the solemnization, the ceremony. What are the rules for that part?
The source specifies it needs to happen before 2 or more witnesses. It has to be performed by someone legally authorized, think judges, certain government officials, clergy members.
Right.
And after the ceremony, the signed license has to be filed with the proper government office. That's what makes it official on the public record.
Got it. License, witnesses, authorized officiant, file the paperwork. That covers ceremonial marriage. The other type mentioned was common law marriage. This sounds less formal.
It is, and it's definitely becoming less common. The source outlines what's needed for it to be valid in states that still recognize it.
Okay, what are the elements?
First, the couple has to agree they are married, and the source really stresses this has to be in the present tense, like we are married, not we will get married someday.
Present intent.
Exactly.
Yeah.
Second, they have to cohabit, live together as if they are husband and wife.
Living together.
And third, they must hold themselves out to the public as married. They need to present themselves to friends, family, the community as a married couple.
So agreement, cohabitation, public reputation. Do the basic marriage rules still apply, like age and not being related?
Yes, those general requirements, being old enough, not too closely related, having the mental capacity to understand you're getting married, those still apply even for common law marriage.
What's the big takeaway here about common law marriage from these sources? Seems like there's a key trend.
There is. The source emphasizes that most states have abolished common law marriage. That's a really critical point for you if you're studying this. You generally can't create a new common law marriage in most places today.
Okay, so it's largely a historical thing in many states now.
Largely. However, the sources also bring up a vital conflict of law principle.
Which is?
Generally, a marriage that was validly formed where and when it happened will be recognized as valid in other states.
The valid where contracted rule.
Exactly. Unless recognizing it would violate a really strong public policy of the state being asked to recognize it.
So if you validly formed a common law marriage back when state A allowed it, and then you moved to state B where it's abolished, state B would usually still see you as married.
That's generally the case, yes. It prevents couples from suddenly becoming legally single just by crossing state lines.
And the source even has a note about legal exams on this.
Yeah, it mentions that for bar exam purposes, you should usually assume common law marriage is abolished unless the specific question tells you otherwise.
That really drives home how limited its relevance is in many places now.
It's a good practical pointer reflecting the modern legal landscape.
Okay, formation covered. Ceremonial and the fading common law option. Now, the sources move naturally to, well, the end of a marriage. 2 main paths are discussed, annulment and divorce. These are different beasts, right?
Fundamentally different.
Yeah.
And getting that difference is key for your understanding. Annulment basically says the marriage never legally happened. It voids it from the start because of some major flaw or impediment that existed when it was formed.
Okay, treat it as if it never existed.
Right. Divorce, on the other hand, terminates a valid marriage. It acknowledges, yes, you were legally married, but now we're ending that legal relationship going forward.
Got it. Annulment, invalid, from start. Divorce ends a valid one.
Yeah.
Let's break down annulment first. The source uses the terms void and voidable marriages. What's the difference there?
This distinction is crucial for annulment. A void marriage is considered invalid automatically from the very beginning, as if it never took place. Legally speaking, you don't even need a court order to end it, though people often get one just for clarity.
Why would a marriage be void?
The grounds are usually pretty serious impediments. A prior existing marriage someone didn't disclose or end, bigamy, incest, being too closely related, or mental incapacity so severe that one party couldn't understand the nature of the marriage act.
Okay, really fundamental flaws. What's the defense if someone claims it's void?
Pretty straightforward, just denying that the impediment actually existed, like proving the prior marriage was dissolved before this one happened.
Makes sense.
The source adds a little wrinkle, too. If the impediment that made the marriage void is later removed, say the first spouse dies, removing the bigamy, the marriage might then become voidable instead of remaining void.
Interesting, so it can change status. What about voidable marriages then?
A voidable marriage is considered valid until a court officially dissolves it through an annulment decree. Unlike a void marriage, you absolutely must go to court to end a voidable one.
And the grounds are different, less severe.
Generally, yes. They often relate more to issues around consent or capacity at the time of the marriage, things that make the marriage flawed but not automatically invalid. The source lists things like one party being underage without proper parental or judicial consent, impotence, inability to consummate the marriage, being significantly intoxicated during the ceremony, consent obtained through fraud or duress, or a complete lack of intent to actually be married. Maybe it was a joke or dare that went too far.
So things that undermine the agreement but don't necessarily make it impossible from the start, like bigamy. Are there specific defenses if someone tries to annul avoidable marriage?
Yes, the source mentions equitable defenses. Things like unclean hands, meaning the person asking for the annulment also acted improperly. Or locales, they waited too long to ask for the annulment, and that delay unfairly hurt the other person. Or estoppel, where the person seeking annulment previously acted like the marriage was valid, and the other person relied on that.
Okay, so even if grounds exist, the court might not grant the annulment based on fairness principles. Now, if a marriage is annulled, void or voidable, it's treated like it never happened legally.
Right.
But what about the practical stuff? Property support. Can the court deal with that?
Yes, and this is really important. Even though the marriage is legally erased, the court can still provide relief related to the time the parties lived together as if married. The source lists things like equitable distribution of property acquired during that time, potential spousal support, child custody, and even ordering one party to pay the other's attorney's fees and costs.
So the court cleans up the financial and parental mess, even if the marriage itself is gone.
Exactly. It addresses the realities of the relationship.
And critically, what about kids born during this relationship that gets annulled?
The sources are clear. Children of an annulled marriage are legally considered marital children. This protects the child from negative legal consequences just because their parents' marriage had a fatal flaw.
That's a vital protection.
Yeah.
The source also brings up the putative marriage doctrine here. What's that about?
Putative marriage. Yeah, this is an interesting one. It's basically designed to protect someone who acted in good faith.
Good faith how?
Someone who went through a proper marriage ceremony and genuinely believed they were validly married, but it later turns out the marriage was legally void or voidable because of some impediment they didn't know about.
So they thought they did everything right, but there was a hidden legal problem.
Exactly. The putative marriage doctrine allows that innocent party, the one who acted in good faith, to use the state's regular divorce laws for things like property division and spousal support, even though the marriage wasn't technically valid. It provides fairness to the person who is innocently unaware of the defect.
That makes a lot of sense. Protects the innocent party. Okay, that covers annulment. Now let's switch gears to divorce and separation. Divorce, as you said, ends a valid marriage.
Correct. It legally terminates the marital bond. The source also mentions legal separation.
How is that different from divorce?
With legal separation, the parties can live apart legally, and the court can issue orders about property, support, custody, much like in a divorce. But crucially, it might not fully terminate the marriage itself. The parties might still be legally married, just living separately under court orders. Divorce ends the marriage entirely.
Okay, a sort of halfway house legally. For a court to handle a divorce, it needs jurisdiction. The source mentions a residency requirement. Can you explain that?
Sure. For a state court to grant a divorce, usually at least one of the spouses must have been a resident of that state for a certain period of time before filing the divorce papers. It varies a lot by state. The source notes could be It basically ensures the state has a legitimate connection to the marriage before it dissolves it. And these matrimonial courts, they usually have broad powers and equity to decide these cases.
Got it. Now, probably the most talked about part of divorce, the grounds for divorce. The source starts with the main approach used today.
Right. The dominant approach, by far, is no-fault divorce.
No fault meaning?
Meaning you don't have to prove your spouse did something wrong, like adultery or cruelty, to get divorced. The legal basis is simply that the marriage is irretrievably broken.
Like it just isn't working anymore, no chance of fixing it.
Pretty much. The marriage has broken down and there's no reasonable prospect of reconciliation. The source does note that many states require these irreconcilable differences to have existed for a specific period of time before you can file for the divorce. That waiting period varies.
So it shifts the focus from blame to the reality that the relationship is over. But the sources also detail fault-based grounds. Are those still around?
They are, yes. While no fault is the main way, Fault grounds still exist in some states. And even in no-fault states, proving fault might sometimes influence decisions about alimony or property division, depending on the specific state's laws.
Okay, so what are some common fault grounds listed in the material?
The source gives several examples. Adultery is a classic one. It's often proved using circumstantial evidence showing your spouse had the opportunity and the inclination to cheat.
Right.
Then there's cruelty. This usually means a pattern of conduct, physical or mental, that harms the other spouse's health and makes living together unsafe or improper.
A pattern, not just one bad argument.
Generally, yes. Desertion is another. This means one spouse intentionally left the marital home, planning to stay away permanently, though it's not desertion if both spouses agreed to separate.
Okay, what else?
Habitual drunkenness or drug abuse that significantly harms the marriage. Bigamy, knowingly marrying someone else while still married to the first person, being imprisoned for a certain length of time, and institutionalization for insanity, but only if there's no reasonable chance the person will be discharged or recover.
That's quite a list of potential faults. And just like with voidable marriages, the sources talk about defenses to fault-based divorce. Sounds like this could get complicated.
Oh, definitely. This is a big part of why fault-based divorces can be so messy and why no fault became popular. The defending spouse has to specifically raise these defenses.
What kind of defenses are we talking about?
The source lists quite a few. For desertion, there's justification arguing you left because the other spouse's bad behavior forced you out. There's unclean hands, basically. The person asking for the divorce based on fault is also guilty of marital misconduct. Provocation, arguing the plaintiff's spouse provoked the behavior they're complaining about. Consent, the plaintiff agreed to the act, like agreeing to the separation or even consenting to adultery, though that's rarer. Connivance is similar, where the plaintiff actually encouraged or helped set up the misconduct.
Wow, okay, more.
Yep. Condonation, this means the plaintiff knew about the fault, like adultery, forgave it, and then resumed the marital relationship, like sleeping together again. That forgiveness can wipe out the fault ground. Collusion, where the spouses secretly agreed to fake the grounds for divorce. Recrimination, where both spouses are guilty of fault grounds. Historically, this could mean neither could get a divorce. And finally, insanity, arguing the spouse didn't understand their actions were wrong when they committed the fault.
Goodness. That list alone shows why proving fault and defending against it could turn into a real battle. It makes the appeal of irretrievably broken much clearer.
Absolutely. It simplifies the grounds significantly.
Okay, so the marriage is legally ending, either through annulment, with related relief, or divorce. The next big step the court has to tackle is often property division. How do they split things up?
Right, sorting out the assets and debts. The sources explain there are two main systems states use for this, and you really need to know which system applies.
This is the community property versus equitable distribution distinction.
Exactly. A minority of states are community property states. In these states, the general rule is that property acquired during the marriage, the marital property gets divided equally, 50-50.
Okay, equal split in community property states. What about the others?
Most states use the equitable distribution system. Here, the goal isn't necessarily an equal split, but a fair one. Equitable. And the sources really emphasize this point. Equitable does not automatically mean equal.
So a court in an equitable distribution state could decide a 60-40 split where something else is fair.
Precisely. They look at all the circumstances of the case to figure out what's fair, which might or might not be 50-50.
That's a critical difference. And the source points out something really important about property division orders compared to, say, support orders.
Yes, this is a huge takeaway for you. The sources stress that property division orders are generally final. They cannot be modified later just because circumstances change, like someone losing a job or getting a raise after the divorce.
Wow. So unlike alimony or child support, which can change.
Exactly. Property division is based on the assets and debts as they exist at the time of the divorce. It's a one-shot deal. You have to get it right then and there.
That puts a lot of pressure on getting the property division right during the divorce process itself.
It absolutely does. It's final. So, okay, how do courts decide what property even gets divided? They have to figure out what's marital property versus what's non-marital or separate property.
What's the general rule for that?
The majority rule, according to the sources, is that marital property is basically anything acquired during the marriage, from the wedding day until the final separation or divorce, depending on state law. That's the pot of assets subject to division.
And there's a minority approach mentioned, the hodgepodge.
Yeah, a few states use this hodgepodge approach. In those states, potentially all property owned by either spouses stuff they brought into the marriage, stuff acquired during, even stuff acquired after separation, but before the final divorce could be thrown into the pot for equitable distribution. But again, most states focus on property acquired during the marriage.
Okay, so under that majority rule, what counts as non-marital or separate property? Stuff that doesn't get divided. The source has that KG mnemonic.
Right. KG helps remember the categories, figure 2C in the source. C stands for property conveyed away for value in good faith before the final separation. A is for an award or settlement for a claim that arose before the marriage, even if you got the money during the marriage.
Like a pre-marriage car accident settlement.
Exactly. G is for property received by gift or inheritance, specifically to one spouse from a third party. Important exception here. Gifts between the spouses during the marriage are usually considered marital.
Okay.
E is for property, excluded by a valid agreement, like a prenup. And the final E is for property encumbered, like taking out a mortgage against it, in good faith for value before the final separation.
So generally, stuff you owned before, personal gifts, inheritances, things you agreed to keep separate. What about whose name is on the title? If the house is only in one spouse's name, is it automatically separate?
The source says generally no. The name on the title doesn't automatically determine if it's marital or separate. It's more about when and how it was acquired.
But there's a catch.
There is a really important one. If one spouse owns separate property before the marriage, like a house, and then during the marriage they add the other spouse's name to the title, the law generally presumes that was a gift to the marital estate. So putting the spouse's name on it likely turns that separate property to marital property.
It's a rebuttable presumption, though, meaning you could try to prove it wasn't a gift.
Yes, you could try to present evidence to overcome the presumption, but the starting point is adding the spouse's name during marriage usually makes it marital. It's a significant action legally.
Definitely something people should be aware of when titling assets. Okay, so the court identifies the marital property. In an equitable distribution state, how do they decide what's a fair split? What factors do they look at? The source lists a lot.
It does, figure 2D. Courts consider many things to achieve fairness. The length of the marriage is a big one. Any prior marriages either spouse had. The age, physical and mental health, current earnings, future earning potential, debts, and overall needs of both spouses.
So the whole financial picture.
Right. Also, any contributions one spouse made to the other's education or career advancement. The needs each spouse has for acquiring assets in the future, their income, medical needs, retirement provisions, the standard of living they were used to during the marriage.
And the source specifically mentioned non-financial contributions, too.
Absolutely key. The list includes contributions to the increase in value of marital property, including homemaking and child-rearing services. This is vital. The law recognizes that managing the home and raising children is a valuable contribution to the marriage that should be considered when dividing assets.
That's crucial recognition. What else is on that factor list?
The value of each person's separate property, because that affects their overall financial situation post-divorce. Whether one spouse wasted or dissipated marital assets, like through gambling or affairs, the economic circumstances of each spouse right at the time of the divorce, and importantly, who will have custody of minor children, as this impacts things like who might need the family home.
That's a really comprehensive list. It shows equitable, involves balancing many factors. What about specific types of assets? The source has a table, figure 290, on how common, sometimes tricky, assets are treated.
Yes, this table is helpful. For instance, professional licenses and degrees, like a medical or law degree earned during marriage, generally not considered divisible property themselves. They're seen more as reflecting future earning capacity.
But what about retirement funds?
Retirement and pension benefits that were accrued during the marriage. Those are generally considered marital property subject to division. This is where tracking timelines is essential, figuring out the portion earned while married.
Okay. What about personal injury money?
Personal injury or workers' comp awards get tricky. The source notes states differ. Some use a marital property approach. If the injury happened during the marriage, the whole award is marital. Others use an allocation approach. They try to separate out parts. Compensation for pain and suffering might be separate, but compensation for lost wages or medical bills during the marriage would be marital. You need to know your state's rule.
That's a significant difference in how that money gets treated. What else is in that table?
Whether business goodwill or accrued sick vacation days are marital property jurisdictions are split. Future interests, like an inheritance you might get someday, Generally, no. Social Security benefits, no. Federal law governs those. Property acquired after separation but before the final divorce, yes. Under the majority rule, it's still marital. Unexercised stock options acquired during the marriage, generally, yes.
It really highlights that dividing property isn't just about the house and the bank account. All sorts of assets need to be classified, and the source emphasizes using timelines.
Absolutely. The source points out that using timelines mapping when assets were acquired, when benefits accrued, when claims arose, relative to the marriage dates is a critical tool for sorting marital from non-marital property, especially for things that build up over time like pensions or stock options.
Okay, property division. Identify marital assets, apply state system, community, or equitable.
Right.
Weigh factors for fairness, if equitable. And remember, it's generally final. Now let's move to financial support that might continue after the marriage ends. The sources cover spousal maintenance and child support.
Right. These are ongoing obligations, and crucially, unlike property division, these orders are generally modifiable if circumstances change down the road.